All right. Hey, everyone. I am back. What's going on, people? Ah, I got a super chat already. Wow. All right. Oh, let me see what this says. It says, just want to get my opinion out first. All right. You are first. This is like the first thing I'm reading. All pro choice people have to get a constitutional amendment passed. It's their job to convince us. Interesting take. Interesting take. Hey, what's going on? What's going on? Thank you for the super chat. You know what? Today, I have the ability. Oh, I missed you guys too. I am going to try to do something that I think isn't crazy. It's crazy. I'm going to try to explain to you the legal framework behind Roe v. Wade, Dobbs, and I'm going to explain to you exactly how the law should work, how the law does work, without the emotions, without calling people baby blanks and, this person wants to deprive. All of that is going to be washed from our mind. This is going to be an extremely hard law video. So if you want the emotional, hey, I'm so happy it's overturned, or hey, I'm so happy I'm so sad it's overturned, this is not that video for you. We're going to be very, very, very technical here on the law. It's going to be entertaining, though. I don't want you guys to think it's going to be entertaining, but we're going to be very technical here. And you're going to learn, I don't care what anybody else is telling you. If what you're going to learn here today is what I used to teach law students at law school, right? And I've got my receipts. You're going to see everything. So I'm going to give you a presentation on how the law developed, why it was overturned, and you, at the end of this video, are going to make the final determination which side you agree with, or whether you can make arguments to hopefully get abortion back in if you want it, or hopefully keep it out if you would like. All right. So that's what the purpose of this video is. It's to be extremely technical and try to cut through all the noise. I don't believe I'm going to be able to do it, but I'm going to give it the college try. So that Hogo really did it. Well, all right. Well, maybe this may just be a little, something, a little, what is it called? Something that overlayers his. So first, let me start, because I created a PowerPoint. It became like 98 slides. So it's gotten there, but we're not going to be on the PowerPoint all day. But so let's start simple. Roe v. Wade was overturned, and what does that mean? We got registration and regulation on firearms are allowed because the law existed before 2A was ratified. 75% of states outlawed abortion before the 14th. Oh, we're going to get there. It is logical to allow regulation on abortion. Grim. We are going to get there. Don't jump out the box. Grim is already there. Don't jump out the box. Let's get through it, because we have a lot to get through. But I want people, after this video, are going to feel like experts, but I've dumbed it down. Now, just so everybody knows, I've had to read, maybe I was on a 5-hour flight going and coming from the wedding. Now, I've read maybe, it's got to be like 600-700 pages of just Supreme Court ruling. So you guys are going to get a lot today. So let's just get into it. Let me just stop this. Blah, blah, blah. Let me stop this. Okay. So first, this presentation is going to be called The Fall of Roe. But we have to understand both the how and the why this is happening, right? How and why. It doesn't make sense for us to start screaming stuff into the ether, not understanding the how and why. So that's what this video is designed to do, to let you understand the how and the why. So first, Roe v. Wade, 1973, it was passed under the right to privacy. So essentially, a woman has the right to make these decisions with her doctor privately, right? Now, this is one of the few times the court has said, well, you have a right to a medical procedure, which abortion technically is. So the court says you have the right to privacy. Now, the privacy rights have been found in other cases, but specifically Roe v. Wade was decided under this right to privacy. Now, in 1992, Roe v. Wade was adjusted a little bit, and the right to privacy turned into the right for intimate and personal choices that are central to a person's dignity and autonomy. So that's what Casey did. So you may hear a lot of people say Planned Parenthood v. Casey and Roe v. Wade. This is why. Roe v. Wade gave you kind of this blanket right to an abortion through the right of privacy, and Planned Parenthood v. Casey kind of just narrowed it to say intimate personal choices that are central to a person's dignity and autonomy. That's the right we're talking about, and that's essentially the right that was overturned in Dobbs. These super chats, I am going to get to them, but I want to make sure that we're clear on those two. So this is what we're talking about. Good morning, Nate. Thank you for doing this. I was hoping someone would break it down before and after and later tatter. Thank you so much. Can you also do an explanation of the court that people are calling responsive to the decision and their basis for yes. I'm going to get there. It's in here, so please just be calm. It's coming. So essentially this is what we're talking about: the right to privacy, and more narrowly, the right to make intimate and personal choices that are central to personal dignity. As you can see, the citations are here, so if you want to read the whole case, go ahead, do it. They're not that long, and you can actually, and the parts that are in quotations, you can go check it out. So that's where we're at. Now, what's the big issue? The big issue that everybody's going to be talking about is that the right to privacy is not in the Constitution, right? Surprise, surprise. But this is what other people aren't showing you. Here are some other rights that have been found to be fundamental, constitutionally protected, that are not in the Constitution. Let's go through them. You have the right to travel, Kent v. Duels. You have the right to homeschool your children, right? To not send your children to public schools. That's Pierce v. Society of Sisters. Constitutional right, fundamental right. You have the fundamental right to marry someone. That's not in the Constitution. You also have the right to have children, the right to procreation. That's Skinner v. Oklahoma, where the government was essentially saying that if you were convicted of certain crimes and if you were a recidivist, they would be able to sterilize you. So for sterilization, they said, no, you have a fundamental right to procreate. Myers v. Nebraska, you have the right to teach your children, a fundamental right to teach your children whatever other languages you want. In that case, they wanted to teach their children German, World War II. No, don't teach them German. You have a fundamental right to teach your children German. Lochner v. New York, you have a fundamental right to contract. Moore v. City of East Cleveland, the right to let extended family members stay in your home. And the Missouri decision, where you have the right as a competent adult to refuse life-saving medical procedures. So if the doctor says, I'm dying of cancer, and I say, I don't want to take any procedure, you have the fundamental constitutional right to do this. And all these rights are unwritten in the Constitution. So as a context. But there's a lot of context here that's being missed, but just to let people understand, these are rights that you have constitutionally protected that are not in the Constitution. So let's go now to Roe v. Wade. Now, this is the opinion from Roe v. Wade, 1973, part 8. And in here, the court in Roe v. Wade says it, admits it right here. The Constitution does not explicitly mention any right to privacy, right? So this is not something that's even, some people are saying it's in there, but it's not in there. No. It's specifically within the opinion of Roe v. Wade. It says it right here. This right is not explicitly mentioned in the Constitution, right? So we're all on the same page. We're talking about a right that's not mentioned in the Constitution. But this is the part that people always fail to see. How do we get there, right? How do we determine rights that are in the Constitution and not in the Constitution, right? What's that process like? That's what I'm about to show you right now. Good morning, Nate from Texas. Thank you for the unwritten rights. I appreciate that you are hosting this convention. Law over emotions, Maddie. Thank you so much. I'm trying. I'm getting killed by a lot of my liberal friends, but it's law over emotion. People are talking about the separation of church and state and results from Roe being overturned. Can you talk about the letters in Texas, Jefferson, where the phrase is found? I'm going to save the super checks for later because I'll think about it. But going back to this, so there's no confusion. This right is not in the Constitution, and it was essentially made up. Right? That's where we're at. Next slide. So this is my question for you. Now, this is the question we're going to answer right now. How does the court determine what rights are constitutionally protected? And then let me take you through that process, because a lot of times people just don't know the process but think they do. So first, the Constitution has written rights, right? Enumerated rights. These are just in there, right? Your Second Amendment right, your freedom of speech, they're in there, right? They're literally in there. So those are simple, right? The court says, okay, these are enumerated rights. They're in there. They're written inside there. No problem, right? But then there are unwritten or unenumerated rights. So it's kind of like, okay, well, is there even such a thing as unenumerated rights? Well, the court says, yeah. But who has the authority? And this is the question that we need to ask, is that if there are unenumerated rights that are not written in the Constitution, right? Who has, number one, the authority to tell us what those rights are and the authority to enforce them, right? Who determines what rights aren't in there? Well, first you have to have some authority to do so. So what authority does anyone, who has the authority to do it, right? And what are those rights? How do we make that determination? That's what we're going to talk about right now. So first, we go to the Constitution. And the Constitution itself says that there are rights that are not listed that are protected. Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So, just so we're all clear, the Ninth Amendment of the Constitution, and then obviously you understand why, right? Because they didn't want this to be like this list where if it's not on this list, you didn't have this right. So the founders were saying, well, listen, there may be, we may not have thought of everything, right? We may have missed something. So in case we've missed something, and you guys find out like, oh, we missed this one, then the Constitution will protect that too, right? So the Ninth Amendment explicitly says there are rights you have right now as an American citizen that are not written in the Constitution. That's exactly what you got right now. So here we go. This is also from the Library of Congress that also shows you that the same thing. This is the most updated version of it. So we have written enumerated rights and we have unwritten unenumerated rights, and where we get the authority from, which is simple, right? So we've just talked about it. Constitution, if it's written in the Constitution, that's the authority comes from the document. Unenumerated, within the Constitution, we have the Ninth Amendment that says, hey, there are unenumerated rights. But now, this is the question, right? This is the key question. This is the question for all these cases. Who has the authority to determine if there is a right, a constitutional right, that's unenumerated? A constitutional right that's not written in the Constitution, right? Something that's not there. Who determines that? Now, it's simple for us now, but that was a huge question in the past. It was a major question, right? Because whoever gets to choose what constitutional rights are in there, right? Or whether or not, that's a hell of a power to have, right? If just imagine the president had that authority or Congress. So who had the authority? And the Constitution itself doesn't say who has the authority to determine unenumerated rights. You kind of got to figure it out. But one branch of government took that power to determine what rights are in there and are not. And that's the Supreme Court. The Supreme Court took that power. It's not in the Constitution. They decided that they were the ones who are best to determine what rights are what rights are protected in the Constitution and what unenumerated or unwritten rights are also protected. Now, the next thing is you're going to say, well, hold on, Nate. What's the authority? Like how did they do this, right? How did they determine, like, we're the only ones that can determine what rights are in there and what rights are not? Well, I got to take you back to a case called Marbury v. Madison. And in this case, the court, Chief Justice John Marshall, the longest serving Supreme Court Chief Justice, he ruled that the court is the body that tells you what the law is. So no matter the president, the president, Congress, it's not them. The court in of itself says what the law is. No textual support from the Constitution, nothing. He reasoned that it is the job of the judiciary to determine what the law is. Now, if you think I'm joking, because I had to bring receipts, because I know you people don't want to hear my stuff. You want to hear the receipts. So here it is. Here is his reasoning why the court has the right to determine what's constitutional or what's not. Let's take a quick read. 1.41. And it is emphatically the province and the duty of the judicial department to say what the law is. Those who apply the rules to a particular case must of necessity expound and interpret that rule. If two laws conflict with each other, the court must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that the case conformably to the law disregard the Constitution, or conformable to the Constitution disregarding the law, the court must determine which of these conflicting rules govern the case. This is the very essence of judicial duty. So the court, in a monster power grab in Marbury versus Madison, says we are the ones who determine what's constitutional and what's not, because we have to interpret the law, and if we have two conflicts, then the Constitution is here over this. The Constitution says this over this. This is essentially Marbury versus Madison, the court's power grab in interpreting the Constitution and being the final say on what the law is. Again, it's right here for yourself. You can read it. Marbury versus Madison is a hard read, but you can definitely read it and see it for yourself. Let me get this. Juris Kennedy based his Obergefell, I think I'm saying the name right, majority opinion on his Romer opinion, which he based on Roe. That Roe is baseless. Aren't Kennedy's previous opinions moot? Kennedy's stated opinion brilliant. I'm not sure, because again, I got to look, because I know Roe is cited in a lot of cases. But again, essentially, if Roe's overturned, all those other cases are going to have the same issue. But I think that's an interesting point. Any cases that I think entirely are dependent on Roe are going down the tube. Will you go through the undeclared human rights? I consider those fundamental human rights. Well, this is about American law. And each country that includes additional rights. Well, I can't go through each country. This is just American law, the U.S. Constitution, and how this thing works. So I'm sorry about this. No, we're just going directly to the U.S. Constitution and American law. I'll look this up, but we're too deep into this, where if I start going on other tangents, this is going to go crazy. So this is where we're at. So now we all understand. So it's important for us all to understand here. The court through Marbury versus Madison, took this power grab and said, we determine what the law is. And that's where we're at now. So when people say, well, who determines? Non-elected judges determine. Well, they've been doing it since Marbury v. Madison. And they gave themselves their power, and we all have accepted it for the past 200 years. If people want to change it, I'm all for it, but this is just the way it goes. Okay? So, now, moving on. So, now we know. Written, enumerated, we're good. Unwritten, unenumerated, you look to the Ninth Amendment. But the next question you should be having is, well, then how the hell do you determine if an unenumerated right or an unwritten right is protected in the Constitution? What mechanism, right? Well, what procedure do they have to determine it, right? Just because yes, I'm saying the court does have the authority, as you just saw, but what mechanism does the court use to determine it? So let's do it. Let me show you. This is Palco v. Connecticut. This case is the case in which affects your life probably more than a lot of other cases that we have. Obviously Marbury Madison is one of the cinema, but this case is the case. Now, it's cited in Roe v. Wade. It's cited in Planned Parenthood v. Casey. It's cited in Dobbs v. Jackson, the one that just overturned it. This is the case that when Supreme Court is looking to find whether a right is fundamental that's unwritten, this is the case they cite. You don't believe me? I know. I need receipts. I've trained you guys. Don't believe me. Believe the receipts. Here we go. Benjamin Cardozo, Justice of the Supreme Court, wrote this opinion. For those of you who don't know who Cardozo is, he is probably one of the, if there was a Mount Rushmore of Supreme Court justices, Benjamin Cardozo would likely be on that Mount Rushmore. He wrote this opinion, and this opinion is so good that it's still being used today, people. Benjamin Cardozo is, if you're talking about, again, a Mount Rushmore of Supreme Court judges, Benjamin Cardozo would be on that list. Look him up if you guys want to look, want to be more educated. But yes, he is one of the, considered one of the greatest justices of the Supreme Court. And he wrote the opinion in Palco. Now, he gives us two ways of determining whether an unwritten rule, something that's unenumerated, an unwritten right is constitutional or not. First is the right. Can the rights that have been deemed fundamental or implicit in the concept of ordered liberty? So you'll hear this ordered liberty a lot. And second, the essence of the scheme of ordered liberty, to abolish them, the right, is to violate the principle of justice so rooted in our traditions, you'll hear this a lot, traditions and conscience of our people as to be ranked as fundamental. So essentially, Cardozo is saying, well, if this right that's not enumerated, if it's fundamental, that means we need it for the concept of ordered liberty, right? For us to do what we do, you need that right. Something like the presumption of innocence. For the court system to really work, the criminal court system to work, you need the presumption of innocence. Without it, it doesn't really work. So that would be something that's fundamental. Or you can have this thing where we have a long history of it. And if there's a long history that it is fundamental to what we do, then that's also going to be a right that even though it's not listed, it's going to be protected under the Constitution. This is the Palco test. This is what the court uses to determine. It's a whole bunch of mumbo jumbo, but this is the test. So, remember we were talking about before. We had, if the right is written, we don't have to worry about it. It's in the Constitution. But unwritten rights, we look to the Ninth Amendment. Then we look to the Palco test, right? Okay, we have an unwritten rule. Ninth Amendment allows us to do it. We're the court. And now let's look at our test, the Palco test, to determine whether this is going to be, whether it's going to be protected, whether it's a constitutionally protected right or not. Now, just because I know you people probably don't trust me, let's look at Roe v. Wade and see what case they cite. This decision makes it clear that only personal rights that can be deemed fundamental and implicit to the concept of ordered liberty. Palco v. Connecticut. They, in Roe v. Wade, they used the Palco test to say that the right to privacy, which is not written in the Constitution, is fundamental. They used the Palco test. Now, we'll go into why a little later. Here's Dobbs v. Jackson. Dobbs v. Jackson, a case that just overruled Roe. Look at what they're saying. Whether the right is deeply rooted in our nation's traditions and whether it's essential to our nation's scheme of ordered liberty. So you see, they're saying the same words. They're saying the same words, right? But if you look at this citation, you don't see it. But let's look a little closer. You see this 19, the footnote. Well, let's look at that footnote. And in that wonderful footnote, the right among those fundamental principles of liberty and justice which lie at the base of our civil and political institutions, Palco v. Connecticut, requiring the principle of justice be rooted in the traditions of conscience of our people as to be ranked as fundamental. So, for those of you who don't believe me, this is obvious that this is the premier test that the Supreme Court uses to determine if an unenumerated right is fundamental or not. I've shown you they did it in Roe. I've shown you they've done it in Palco. I've shown you they did it in Dobbs, right? Each one is using the Palco test to determine whether a right is fundamental or not. Now, am I boring you people? Because I feel like this deep law stuff is getting boring. So let me look to see if I got any super chats. But yeah, we're going deep here. So I know I've got, and I always have the fear that going so deep into the weeds, and as you can see, I've been reading all this stuff. Going so deep into the weeds, it can get confusing. So let me take a couple of these super chats because I don't want to lose you guys. So we did this one. Could use the same logic applied to Roe. be applied to Loving. Yes, but I'm going to show you the difference between Roe and Loving. That's something that's been put out there that's hogwash, but we're going to specifically look at that. We're going to specifically look at that. So it's a good question. I just don't want to. I don't want to give away the end of my slides here. I think Cardozo was one of the jurors who said stare decisis need not apply to unconstitutional decisions. Same relevant to Roe being overturned. Smart. Yeah. Rare. That was good. That was very good. Yeah, you're right. WH Asian. I'm not a lawyer, but for all those freaking out, this doesn't outlaw abortion. Many states will allow it. If not changed, I am correct. Yes, you are 100% correct. This does not outlaw abortion. What it does, it allows it just says it's not constitutionally protected on a federal level. So every state can either outlaw it outright or they can allow it. As a matter of fact, some states have made it a constitutional, based on the state constitution, a constitutional right based on state law. Can you talk about the right to privacy? OBGYN concerned about this. Many women's safety issues. Yes, we're gonna talk about a little bit more about the right to privacy. But again, this was just the introduction on how this was an introduction on how the right has developed and what gives the Supreme Court the authority to do this and what tests they use to actually implement this. See, you guys are getting this. This is, again, people pay hundreds of thousands of dollars to understand it at this level when you go to law school. I'm giving it to you for free. So understand this. So you're getting a very high level understanding of this topic. One thing concerning folks is that the court explicitly did not excuse substantive due process as a principle. Perhaps it should be, but wasn't there. Correct. So we'll talk about substantive due process in a second. I just don't want to jump the gun with that one. And this is how you get a bajillion red regs. I'm not sure. Fed regs. This is how you get a bajillion Fed regs. Okay, federal regulations. Yes, I don't know why I was reading that so bad, Rambunsky. Sorry, but yes, this is exactly how you do. This is exactly how you do it. Thank you for the generous super chats, guys. Because I didn't honestly, I didn't think I was going to get any super chats. I was like, I'm just actually teaching, but this is something I love to do. So thank you. I appreciate you guys really do. The weeds aren't always sexy, but sexy talking points on both sides. For so long, probably how we got into this mess. Thank you for doing what you do and breaking this down for the rest of us. Oh, thank you so much. Thank you, A-Train. I appreciate it. This is difficult. This was a lot of reading, but I'm breaking it down so you don't have to read it. Let's get back to the good stuff. So we've talked about if they're written and enumerated, Constitution, we're good. And if they're not written, unwritten rules that we want to put in the Constitution, that we want to say are constitutionally protected, the Palco test is the mechanism in which the court uses to determine if they're fundamental. And we've seen that in both. I've shown you that in Roe v. Wade. Nobody else is showing you this. Let's just be clear. No one else is showing you this type of detail. I've shown you it cited in the Roe. I showed it cited in Dobbs, and we're going through this. So nobody else is showing you this level of detail. This is it, and directly from the cases. I had to read these things. It was crazy. So now let's go on. So now let's talk about how Roe tried to overcome the Palco test. The reasoning for Roe saying that the right to an abortion under the right to privacy overcame the Palco test to be considered a constitutionally protected right. Phoenixburg says, you may be teaching, but the class still has questions. Thanks for this day. No problem. Yeah, please. Yes. Please ask your questions. So here we go. So this is how the Roe court tried to explain to us how the right to an abortion through the right of privacy should pass the Palco test. So let's read it. Please hold over on super chats until the end. This is confusing enough without the interruptions. Okay, well, I'm going to do super chats throughout, but I get it. Hopefully, I'm not confusing everybody. I'm trying to go very slow, but I'll try to keep super chats to a minimum. So let's start reading here at the top. It says the Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps to Union Pacifico v. Botsford, the court has recognized that a right to personal privacy or a guarantee of certain areas or zone of privacy does exist under the Constitution in varying cases. The court or individual justice have indeed found at least the roots of the rights in the First Amendment, and they cite Stanley v. Georgia. So you know what I did? I went and read Stanley v. Georgia. That's what we did, right? Let's see what Roe is saying. The right to privacy is deeply rooted in our tradition. And here are some other cases that also prove that, yes, this is it. So they said, look at Stanley v. Georgia. I did. Written by Supreme Court Titan, first African-American Supreme Court, and a unanimous decision by Thurgood Marshall. This is what that case was about. The court held that the First and 14th Amendment prohibited the making private possessions of obscene materials a crime. Now, in this case, this was about pornography. Somebody had pornography. The police had a warrant to search the person's home. They found pornography. They said it was a crime to just have pornography, and this guy was criminally charged, and it went to the Supreme Court. In the majority opinion by Justice Marshall, noted that the right to receive information and to personal privacy were fundamental to a free society. Marshall then found that the First Amendment, if the First Amendment means anything, it means that the state has no business telling a man sitting alone in his home what books he may read and what films he may watch. The right to privacy, no? Thurgood Marshall. That's from Roe, right? That's from Roe. And this is what Roe cites, right? The personal privacy were fundamental to a free society. Sounds like the right to privacy to me. So, in this case, Stanley v. Georgia, the court cited through the First Amendment that you had a right to privacy, right? I have a right to look at pornography if, because it's a First Amendment issue. And it's unwritten, but passes the Palco test, right? Boom, we're good. So now they go on to some other cases. Another case they bring up is Katz v. United States. But in Katz, this was a Fourth Amendment issue, search and seizure. And here, the court says, and whether an individual may harbor a reasonable expectation of privacy, because the police were illegally searching something. So they said, you have a reasonable expectation of privacy, right? He is entitled to be free from unreasonable government intrusion. This is an expectation of privacy against unreasonable searches and seizures. Privacy again, the Fourth Amendment. Here we go. So we got Katz. So they're going right through it, right? The right to privacy is everywhere. We got it in Katz. We got it here in Georgia. We got it here. And they're listing all these cases. Now let me go here. And in Katz, this came out bad, but in Katz, Fourth Amendment, Fourth Amendment plus the right to privacy gives you this unwritten constitutional right to privacy. But it's based on either the Fourth or the First Amendment. And they say that in the ruling. And then they go on and then speak about other cases that also mention the right to privacy. For instance, they even talk here about the Ninth Amendment. They talk about the concept of ordered liberty. And then they say, based on all these other things, Palco is satisfied. Based on everything we're seeing here, Palco is satisfied. And at the end, at the last line, I should have highlighted this, they mentioned Loving v. Virginia, which has been in the news right now. And Loving v. Virginia is a case in which the state of Virginia outlawed interracial marriages. And the Supreme Court said, you have a constitutional right to marriage, and you have a constitutional right to marry whoever you want. But they did not decide this under the right to privacy. They decided this under equal protection. So the court in Loving v. Virginia said the equal protection clause doesn't allow the government to outlaw interracial marriages. So now when people are saying, well, no, Loving v. Virginia is going because of the right to privacy. No. That's it's one of the most fundamental equal protection cases. Whoever telling people that is wrong. The right for interracial marriages has nothing to do with the right to privacy. This is an equal. This was ruled under the Equal Protection Clause, where Roe wasn't an equal protection case. Roe was a due process of law case, which is different. So, interracial marriage, equal protection, Roe v. Wade, due process. Now, one of the things that I think are concerning to a lot of the academics is that Roe always had a problem. And that problem was always it not being an equal protection case, right? You could make an argument Roe would be better suited as an equal protection clause, right? Women versus women can't get pregnant, men can't get pregnant, so an equal protection case would have been on more solid footing. And I agree with that. And you know who else agrees with that? Ruth Bader Ginsburg. Ruth Bader Ginsburg also believed that Roe had issues under this privacy scheme and thought it would be better if Roe was actually decided under the equal protection scheme. And that's what she said at the University of Chicago, right? That, there's a critique of this where it is vulnerable to attack because the reasoning is not based on equal protection, but this right to privacy, which is, again, made up by the courts. So, again, Ruth Bader Ginsburg even had some issues with Roe. But obviously the underlying principle that women should have this right, I like Ruth Bader Ginsburg, agree with. But the way it was done, that is why we had the issue. So, when it came to Stanley v. Georgia, remember, First Amendment, privacy, unwritten, we're good. Katz, Fourth Amendment, privacy, unwritten, we're good. But Roe, we did not have that attachment of either like a First Amendment right, a Fourth Amendment right, we didn't have that. It missed that, right? It wasn't trying to find privacy within a search or find privacy within free speech. It was just like you had privacy, but there was really no constitutional context that gave you this right to privacy. So the court now in Dobbs were like, this doesn't, these other two cases don't really help Roe get over that hump, don't really help Roe meet the criteria of a Katz or of a Stanley, because Roe doesn't point to the Fifth Amendment or the Sixth Amendment. It just kind of is just there and it says, hey, you have this right, but it doesn't really give you any context within the Constitution of some other right that it's really expounding upon. And that's what the recent court, that's what the Dobbs decision said. Now there is another way outside of this scheme to get the right, to get an unenumerated right under PALCO. And that way is if it's rooted in tradition and the conscience of our people to be ranked as fundamental. So let me be very clear. If the right isn't really attached to, let's say, the First Amendment or Fourth Amendment, like those other two cases we saw, then you can still make the argument that this right is based in our tradition and our conscience as a people, right? And that these rights are so fundamental that, even though they're not in there, it's like a duh, right? You should have that right, and that right should be protected. And the reason why it was left out is maybe because they didn't think about it, but it's just so fundamental to who we are as a people. That's why we're going to recognize this right. And some people believe that abortion fits that category just based off of what it is, your right to make decisions with the doctor. But obviously that's now an argument that's got to be made in court. But this is another way. This is another way to satisfy the PALCO test. Now, when you look at the Dobbs versus Jackson opinion, the opinion that overturned Roe, it says it right here. In deciding whether the right falls to either of these categories, whether it's enumerated or unenumerated, the court has a long-standing ask the question. Again, this is the case overturning Roe. This is what they're saying. This is what the court is saying. Whether the right is deeply rooted in our nation's history and traditions, and whether it is essential to our nation's scheme of ordered liberty. I am good, right? This is it's right here, right? It's right here. It's right here. So the court in Dobbs said, the Supreme Court now says, Well, now it's not attached to one of those other rights. So let's see if it's in their if it's within our tradition. So let's look at some other cases that have found where it hasn't been attached to one of these other rights, but it was just so fundamental to who we are that yes, we're going to extend. This is a constitutional right that's protected. So we're going to go back to this list. The right to travel. It wasn't really attached to there, but they said this is just so fundamental that yes. The right to either homeschool your children or not send your children to public school. They said, yeah, that's a fundamental right that we've had since the beginning of time. You have the right to raise your children. It doesn't have to be in the Constitution. And it's tradition. It's been, that's how it's been forever. The right to marry someone. Yeah, the state can give you a license and so forth, but you have the right to marry whoever you want. It's a fundamental right? It doesn't have to be written down anywhere. We know it's a right. People have been marrying each other before the country was created. You can regulate it in certain ways, but you have the fundamental right to marry. It's not in the Constitution. The right to have children, right? What other right is as fundamental as that, right? If you're an adult, you have the right to have children. So fundamental, right? I don't think anybody will question the right to have children is extremely fundamental to our way of life. It's tradition, right? We've been doing it for the beginning of humanity. Yeah. These are the rights that they've been finding are in there, right? The right to teach your children other languages. Court said that's fundamental. The right to enter into a contract. Court found that to be the right to have your extended family stay with you in your apartment, right? The government can't tell you who you can live with, right? If it's your family, there you go. So these rights are and the last one obviously here is the right for competent adults to refuse life-saving medical procedures. Again, that's your right. These are not in the Constitution, but these rights are so deeply rooted in who we are as a people that I don't think anybody would say, hey, this isn't, it isn't fundamental, right? Now, someone says, oh, wasn't slavery very precedented? Yes, this is true. But it was overturned by the 13th Amendment. They wrote an amendment to overturn that. And that's what you do. If it's that deeply rooted, you write an amendment, and then that amendment becomes the law. Remember, these are unwritten constitutional rights. Slavery was an unwritten constitutional right until they wrote in that it was no longer an unconstitutional. It was no longer a constitutional right. Matter of fact, it's illegal, right? It's forbidden by the Constitution. See, good point. See, so it's funny how even if somebody's trolling you, they can actually help you make a very good point. And that's a damn good point they help me make. All right. Let me get some of these super chats that I've been putting off for a little while. Sorry. I just want to make it very. So we just talked about the Roe being applied to Loving. Roe was under equal protection. Roe was under due process, which is privacy. Loving was under equal protection. It was ruled under equal protection. I think those is one of those justices. Oh yeah, so we read that. Please hold on for super chats. We read that, but this is a nice little break. What about precedent? We're talking about precedent. You're seeing it right on the screen. Great question. If a clinic offers loyalty rewards, i.e. free caramel macchiatos with every 3 abortions, and I'm hypothetically on my 3rd, would I no longer be entitled to the Moscato if the state bans the practice? I think so, right? I don't think you'll be able to get it. Thank you, Amber Attorney. I don't think you'll be able to get it, right? If they banned it and you're trying to get your 3rd, looks like you're out of luck. I'm a retired federal policy wonk. Authorities are the basis of all federal policies. Yes, all. Knowing authority is how you counter federal policy. Amen to that. Very, very, very good. That's perfect. I couldn't have said it better myself. Thanks. This is bringing up so many feels. Haven't cried until today. Happy tears. We will get this right again. Had an illegal blank in 1972. I'm sorry to hear that. And I know how much we need our freedoms lawyered. Thank you. Thank you for the super chat. Yeah. I don't worry that conservatives may have just snatched defeat from the jaws of victory, from the jaws of a landslide. You're talking about the political ramifications of this. Interesting. Does the right to privacy mean you have the ability to do what you want, to do whatever you want in private seems sus. No, it doesn't seem that. It's laid out. It doesn't mean that. The no right is absolute. Thanks for taking us through this, Nate. You're one of the few actually taking us through the facts versus emotions. Very appreciated. I thank you for that. Thank you for that. I've been trying, but I knew this was going. This presentation is always a killer because there are just so many emotions behind it, and I do understand it. But I think just a factual understanding of the situation, of how it developed, and how moving forward it can develop. You can change the law. You don't know how to change the law unless you know how the law works. And I think this is the issue here. Most people just didn't know how the law works. So hopefully now this will give people a better understanding. This says, why do you think Thomas now wants to come after same-sex relationships and the ability of married couples to get contraceptions? Because those two principles, contraception and same-sex relationships, were under the right to privacy. And Thomas is saying the right to privacy, which I showed you earlier was just made up, is something that is not protected. Thomas feels the right to privacy fails the Palco test as a right. And he believes that it only passes if it's attached to another right, like I showed you earlier, either the First Amendment or the Fourth Amendment. You can have a right to privacy in your personal effects. You can have a right to privacy in what you read, but you can't have a right to privacy just as a general rule. So Thomas believes anything that's based on the right to privacy should be overturned. Loving v. Virginia is not based on the right to privacy. It's based on the right. It's not based on the right to privacy, but it's based on the equal protection clause. So that's the reason why. But great questions, guys. All right. So now let's move on. Here we go. So back to our chart. So again, we had written enumerated rights. If they're in there, we're good. If they're not in there, we had our process, right? Rights not in there. Ninth Amendment gives the court the authority to put them in there. And the court uses the Palco test to determine if they should be in there or they should not be protected. So now, the right to an abortion. It's not in there, right? We already said it. Roe says it's not in there. So we got that. It's not in there. But the court now in Dobbs says it fails the Palco test. So since it fails the Palco test, then it says, well, it's not in there. And they give you two reasons why. They say, well, this whole framework of Stanley, versus Stanley, Katz, and then Roe v. Wade, this doesn't work because Roe v. Wade does not point to a particular constitutional amendment that's already recognized and just adds the right to privacy to it. It doesn't do that, right? So we're just not going to. So it kind of stands alone as its own right of privacy. So we're not. So we can't use this logic. So with that said, they said, well, based on that logic, then the right to abortion, in of itself, and the way it's laid out, can't stand because it doesn't satisfy the Palco test. And about it being, and the court also makes mention that when it comes to whether it's tradition, whether it's ordered liberty, well, when they look back on the history of how abortion was treated in the United States from the beginning, it was always, most states had it illegal. Even up till Roe, most states had it illegal. So the recent Supreme Court said, well, hey, since, when we look at our tradition, this is not like marriage, which it was legal in every state, right? This is not like you get the right to raise your children away, which was legal in every state. This is something that was illegal in almost every state, illegal in almost everywhere, right? It just recently became legal. So this doesn't have this long tradition or history, right? So since you can't attach it to a regular constitutional right, and since it doesn't have this long history, actually it goes the opposite, we are going to say that this right is not within the Constitution and does not satisfy the Palco test. So we're going to give it back to the states and say the right to have an abortion is not constitutionally protected. Now, that is the law. You guys now know exactly why this fundamental right of an abortion was now overturned as not being protected by the Constitution. Now, there are arguments on both sides. Like one of the arguments that you're going to hear now is that, well, what makes abortion different than any of these other rights, right? What makes it different than the right to marry? You know, it is pretty much fundamental. What makes it different than the right to, if I have the right to have children, why don't I have the right not to have children, right? You know, that's Skinner. Skinner says you have the right to have children. Well, don't I have the right not to have children if I don't want to, right? But I think one of the issues with Roe that always comes up is that Roe is a unique situation in which the proponents of Roe are essentially saying women have a right to a medical procedure, right? We have the right to this procedure, and that right is constitutionally protected. And the court now is saying, well, you don't have that right to the procedure. For instance, when it comes to forced sterilization, the government was sterilizing people. And the court said, no, the government can't sterilize you. The government can't do that. But here, it's not the government forcing you to have an abortion. It's the government saying you can't have one. We're not going to allow it within our state. So the mechanism is a little different. And here, the government's saying we just don't allow that here. It's not saying you have to have the abortion. It's saying we don't allow that here. So the mechanism is different. But again, some people are saying that if these rights are protected, then obviously the right to make an abortion, to have an abortion, make an abortion, the right to have an abortion should also be protected. So that is the presentation. What do you guys think? Let me go over some super chats. I'll answer some questions, go over some super chats. But that is the end of the presentation. Now you should understand a couple of different things. All right. Number one, how the Supreme Court got the authority to make these decisions. Number two, rights that are not in the Constitution, how they are determined to be in the Constitution, right? How they are determined, how the court determines what are and what not. We saw the case and we saw how everything was put into place. Then we saw other rights that were not in the Constitution that went through the Palco test and passed. Then we saw how this court, the Dobbs court, the recent Supreme Court judgment, kind of went through it and said, well, the cases that were even cited in a row don't really help the case. And the fact that the ordered liberty piece and the fact that it's long tradition also don't satisfy it. So based on that rereading of Roe, it doesn't seem like Roe passed the Palco test, and that right is not fundamental based on the current standards of the Supreme Court. Now, maybe they may change Palco. They may add some other context to it. They may change the test. But as of right now, they're saying this doesn't pass our Palco test. Buck v. Bell is still valid law on sterilization. Yes. Oh, yes. Buck v. Bell, too. I was just going to the beginning, though. But yeah, Buck v. Bell is definitely potentially criminal. Let me see. I think I had something else here. This one says, I'm confused about how Roe v. Wade's right to privacy is different than HIPAA. Been waiting. Well, HIPAA is a state stuff, right? And I think it's some federal HIPAA, but it's not a constitutionally protected right. Like, there's no HIPAA is a statute. It's not a constitutionally protected right. So yeah, so if Congress passes a statute or the state legislature passes a statute, then you're protected. But without that statute, then we're back to where we're at. So yeah, so HIPAA is not a constitutional protected right. It's a regulation by either state or federal government. But good question. Let me see if I can get some more questions out here. Elevator pitch, substantive due process, and why it's a mess. Oh, I have to go to Justice Thomas's concurrence in in McDonald, where he goes over it. But yeah, it's a mess. And that's what we're going through now. That's why the road thing is a big issue. It's a mess. If you have a question, you can either super chat or type question, and then in your message, and I will try to answer it. I'm gonna go through a couple of more if anybody has any questions. This one, he didn't answer the question. Why doesn't the Third Amendment codify a right to privacy? Doesn't it basically protect the sanctity of the home? Yes, it does. But again, the problem is who gets to determine that question? It's the Supreme Court. So the Supreme Court in the 70s, 7-2, said there's a right to privacy, and abortion fits within that right. 2020, they said, well, they got it wrong. And here's the reasons why. This is where we're at. So, yeah, this is why now somebody's going to have to make that argument within the Supreme Court that this right should be attached to the Third Amendment. I believe women should have the right to their own body. I also believe men should pay for child support, given proper and timely notice. Yeah, I agree. I agree with that too. Taylor Swift. I thought Justice Thomas' concurrence argued against substantive due process. Yes, he did. He always argues. He hates substantive due process. Yes. On which is broad right to privacy was built. Yes, but a whole bunch of other stuff was built. Substantive due process gives us a lot. So just so we're clear, substantive due process, the fact that the New York State case for gun rights, that's a substantive due process case too. That applies the Second Amendment to the states. That's how we got that, right? A lot of the free speech applies to the states is through this process of substantive due process. So yes, substantive due process, even though he hates it, that takes the Bill of Rights and applies them to the states. So he has an issue with it, and his issue with it is that it should properly, just so everybody knows, Justice Thomas believes in substantive due process. I want to make it very clear. He believes in it. He just believes it shouldn't be under the mechanism that it is now. It should be based under the 14th Amendment's privileges or immunities clause. That's what he believes it properly should be. He didn't argue against the right to privacy, but it found it could be supported elsewhere. But he also did that with the Second Amendment cases too. So this is going to be a little more nuanced. But Tyler, you're right. But it's a little bit more nuanced. Wouldn't an amendment for abortion solve? Yes, automatically, 110%. Yes, it would definitely it would solve it like tomorrow. But that ain't going to happen. Question for fantastic contextualization of the issue. You made a really interesting argument within civil law of pregnancy being forced if abortion is out. Could the 13th forced labor be used to argue a 13th Amendment justification? It could be. It'd be interesting. But you got to go to the Supreme Court and convince those justices that labor in 13 also means labor with pregnancy. That's a bridge you got to cross. Because again, you got a hot bench up there who don't want to find this right, but you have to tell them this is where you would find it. This is either we have a tradition of it, which they've obviously, none of them believe that, or we can work it into one of these already, all of the rights we already have, or it's already been enumerated. And that I think is going to take some work, but this is interesting. I think it's an interesting workaround. Have you analyzed the Dobbs dissent yet? No, I haven't gone into the Dobbs dissent. I read it, but I didn't really want to go into it because I think what they're saying Roe was correctly decided, and essentially, yes, all these cases apply. But if the dissent was the majority opinion, I would be saying the exact this slide would not change, except it would just have the majority opinion. But the slide would not change, right? So that's what I wanted to really put. These slides and this presentation doesn't change no matter how the case came out. You just now, everybody here who's watched this now exactly knows the mechanism of how things work. Question: do men don't have to bear children? Why it's not a choice, but biology. Shouldn't women have the right to choose not to bear children? Equal protection, then privacy. But still, yes. And that is what Ruth Bader Ginsburg, you're making Ruth Bader Ginsburg's argument. Remember earlier when I showed, let me put this up again. Remember earlier when I showed that Ruth Bader Ginsburg says, yeah, Justice Ginsburg thought Roe was wrong case to settle abortion issue. And she feels that way because she feels that it's an equal protection issue. Women can get pregnant, men cannot. It's equal protection. They want equal protection under the laws. This would have made Roe harder to overturn. But she lost that argument. Ruth Bader Ginsburg lost that argument. Crazy, right? She lost it. And now Roe is overturned because they said the right to privacy is BS. So it's just so fascinating how things turn out. But she's been saying that for years. And this was 2013. She even said this again. So it's an amazing, it's amazing how she had the foresight to see that this was problematic. There was another question that came in. It's a little tough to watch. This is John again. John O'Brien. No, 2A is not substantive due process. It is deprived of meaningful. It is the deprivation of meaningful procedures, but only pure discretion of a licensing officer. Hold on. You need to read his concurrence, and I think Heller, where he makes the point, the 2A opinion in Heller, which the new case is based on, is strictly substantive due process. And he rails against it. He says, no, it's BS. It should be privileges or immunities clause. It's BS. But I've joined it because I agree with it, but it's BS. And I write, and he said he writes separately to make the point. So read his concurrence. I'm not sure if it's concurrence in Heller or McDonald, but read his concurrence. And he's purely. Now, this case, I think you're right. He doesn't make that argument again, but he damn sure made it in that concurrence. Matter of fact, I think I can even find it, but he damn sure made it in that concurrence, and he damn sure said, yeah, this is because because the issue was, and for those of you who don't know, with the Second Amendment, the issue was before, was it an individual right? And Justice Scalia and Heller said yes, it's an individual right. And he incorporated to the states through substantive due process through the Second Amendment, right? Through the 14th Amendment. So he applied it to the states through the 14th Amendment and said, now the states have to essentially allow you to have this individual right of gun ownership in the home. And now the court has just extended that to outside. So it was keep arms. And so a lot of people don't realize this. So I'm giving you a little bit more Supreme Court insight than I wanted to. But hold on. Let me pull this down. I'm giving you guys a little bit. Somebody said I missed their super chat. Don't worry, I got you. What was I? Don't want to miss my point. I missed my point because I was looking for that super chat. Somebody said I missed. What was the point I was trying to make? Now I forgot it. I'll figure it out later next time I remember. Women seem to forget it takes a man to make a child as well. If the man wants a kid, the man should get to keep it. Women can't just decide alone. But again, these are legal arguments, right? These are arguments that you have to make to the Supreme Court. These are not arguments that these are arguments that you got to make to the Supreme Court. Who has that right and who doesn't, right? That's kind of where we're getting at with that. I do understand what you're meaning, but that's where they believe equal protection would have been better because women can only get pregnant. So why make them suffer, right? The equal protection argument. Question. In the name of equality, why aren't men afforded the right to opt out of fatherhood? Women have the option, men don't. How is that equality? But that's why it's an equal protection issue, right? Women can get pregnant, men cannot. Why force them to go through 8 months of pregnancy and then, possibly dying? Giving birth to a child that they don't want to give birth to. Yes. Mods, Nate didn't. I got it though, Max. I got it. Max, you gotta write your super chat again, Max, because I definitely didn't get it. Write it again, Max. Write it in bold so I can see it. You don't have to super chat again. I'm looking for Max's new message. Max, write your super chat again so I can get it. Don't super chat it though. Just write it in bold letters so I can see it. Question. How can the federal government or schools entirely leave the issue up to the states because a particular state can go to the other extreme like 6? Yes. Because, well, just so we're clear, the federal government is a government of limited authority. So the Constitution, a lot of people don't forget to realize the Constitution says what the government can do. And if it's not in the Constitution, the government can't do it. So in this instance, the Supreme Court is essentially saying the federal government has no right to tell the states that the right to an abortion is protected by the Constitution, and that the states have that right because, again, we're moving from the 9th to the 10th Amendment. If whatever rights that are not explicitly given to the federal government, reserved by the states, and the state has the right to do whatever it wants in this particular area. So that's why. Question. Is there no article or basic human rights in the Constitution of the United States? Well, the rights that are listed there and the President of the Supreme Court kind of gives that to you. I'm trying to look for Max's, Max. I don't see you again, Max. I was looking for you, Max. Max might be gone. Max, I'm so sorry. I'm looking. I don't see you, Max. Max. All right, so I missed Max. Max, I'm gonna try to look for your super chat, Max, but it's a little tough right now because I'm trying to go through all these questions. Sorry, Max. Please. What is a good lawyer drink? I don't know. I like scotch. What's a good lawyer drink? And we like beer too. Here we go. This is my law lesson for the day. You're amazing. Thank you. God bless you. Thank you. Thank you so much. Thank you so much. I'm glad you guys like this. Con law is often 2L, but yes, you can't honestly read Roe and conclude that it is a result of good. Yeah. And a lot of people haven't read it, and that's why we do something like this. Thank you for that. Yeah, you're 100% right. Michael says, you were looking for Thomas's occurrence in Heller and McDonald. Yes, I was. 2A, F Thomas, 2A. Yes, I forget the point I was trying to make. I'm sorry, guys, because that other me missing the super chat threw me off. But there was like some grand point I was going to make with it, but I totally forgot it. If I remember it, I'll let you guys know. I'm sorry. This one, please explain how they can just amend the Constitution, please. We just went through that. You got to watch the video from the beginning. It's so like no one knows that they can write abortion to the Constitution. We just went through this whole thing. Control F for Max. Let me do that. You got to do it. Yeah, it's not coming up. This is weird. I did Control F for Max, but it doesn't do it. Let me see if it pops up anywhere now. Nope, it's just popping these up. It doesn't just go through the scroll. Thanks for that Control F for Max tips, guys. R.I.P. Max. I'm looking for Max. Yeah, but you have to watch from the beginning because I have to go through the whole presentation to explain that. But I think, please, people, let them know. It's there. Thomas Clerk said this decision was revenge. Oh, I know it now. You see? Thank you, because people kept mentioning Thomas. All right, so for the gun decision, I just want to make it very clear what the gun decision actually did, and what I think a lot of people are forgetting about the gun decision. I want people to understand this. So the original decision in Heller and McDonald had to deal with keeping arms, right? Because don't forget, the Second Amendment is about keeping and bearing arms. So keeping arms was, I got the ability to keep arms in my house for personal use. But this new decision with New York State was about bearing arms. And so Heller said you can keep arms in your house, but then it was, well, what about bearing arms? So this case was saying, well, now you have a constitutional right to bear arms because it's keep and bear arms. So that's what this second case was. It was extending that right to say, okay, we've interpreted keeping arms, but now we're going to interpret what bearing arms means. And bearing arms means you have the right to bear arms outside the home. Which, obviously no right is absolute with certain restrictions, but that's where they were going. You're right. McDonald adopted the Cardozo words. No. You see, John? You come and challenge. John's an attorney. You come and challenge me. I don't think he considers substantive due process, but rather a traditional principle. See, thank you, John. Thank you. See, John was checking me, but didn't think I knew it. But yeah, of course he adopted. Why? Why did he adopt Cardozo's words? It's because that's the way it's done, baby. That's the way it's done. That is the way it's done. Boom. Thank you, John. Thank you for that. All right, guys. I'm going to Control F Max one more time to make sure I don't see. All right, Max power. The question went to the graveyard. Max Gina. You don't have the right to decide what happens to others' bodies. A fetus is another's body. Interesting. But you have to do something, right? You have to convince the Supreme Court that that's the way to go. This one says, let's go. Your Thomas keeping over super chats. Not sure you're aware or if it's intentional. All right, let me go back and look at this because I've been the way this system has been doing it. I'm going to go back and go because I don't want to miss anyone's super chat. So let me do this. This system is obviously not catching them all then. So I'm going to go back and do this because I definitely don't want to intentionally miss anyone's super chat. And I think this system is doing that. Then I'm going to go old school and look at it. Give me 1 second. Sorry about the wait, guys. but I am not happy if I am missing, because I really appreciate you guys looking out for me. So sorry, I'm just going to the back end. I'm just going to look at the super chats from the back end. It's a little tedious, but I want to make sure I get everyone's super chat, because I think this is a topic where we can all learn something from it. All right, so I'm going into the back end just to make sure. And we are going into super chats to see. Let's go to super chats. Come on, monetization. Supers. All right, so here we go. I'm going to see all. So I'm going to be doing them off of this list instead of this other list. And I can do my Control F for Max here. All right. And I'm going to share this screen. So I'm not going to be doing super chats off this screen. I'm going to go back to this other screen. Share screen. All right. And we're going to go back. Sorry about this, guys, but this StreamYard system is not working. So I'm going to this other system so we can see the super chats. Boom. All right. So we should be able to see super chats now. And I'm going to add to stream. Blow it up, and here we go. So we are going to do this way. So super chats that come in, this catches them all, and we are going to be reading them. So now I Control F for Max, because Max Power, look who super chat came up. Can Roe v Wade, make sure you guys can see this. All right, see Max? I got you. Can Roe v Wade now be argued under equal protection? Yes. In order to reinstate the right to abortion? Yes. Also, hit the damn like button, people. Max, you see? I'm happy I actually found your super chat. Due diligence, baby. Due diligence. All right. I believe women should have, just making sure, see if I missed anything. I thought comments, we've talked about that. What an amendment, yes. Solve the abortion issue, we read that. We read this one. Let's see if I missed any I didn't read. Question. We read that. No, 2A is not substantive due process. John said, but now he's changed his mind. Women forget. We read that one. This is my law lesson for the day. So we've been reading a lot of them. People keep saying, I keep missing them. Please explain how you could just amend. We went through that, Chat Murphy. We went through that. It seems like no one knows what that abortion is a gun. So we went through that. Thomas's clerk. So here we go. You're right, McDonald Dop. This was John. So this is where we left off at. So doesn't the far left push the pregnant man and removal of gender to eliminate equal protection argument? Or would it still function since it's a niche? Well, the equal protection argument is simple. The equal protection argument is one. Hold on, let me blow this up. The equal protection argument is saying that we want to treat men and women equally, but only women can have this, only women can be pregnant. So that's the equal protection piece, that this is to treat women and men equally. So, that I'm essentially would be the equal protection argument. But most scholars believe the equal protection would be harder to overturn. And I think that's where they're going to go to. I think the 14th Amendment Incorporated doesn't establish substantive due. Maybe you're right. I have to think about that one, John. Chat Murphy says, no, the actual procedure to amend the Constitution, like write another amendment. Yeah, but don't forget you have the Chat Murphy. But don't forget you have the 9th Amendment, which says there are rights that are not in there that can be found. Right? And those rights, there's a right that's not listed there that's fundamental. Then that right is protected as if it was written inside there. So some people call that amending the Constitution, but we have a 9th Amendment that allows them to do that. And if you think about that, that makes sense, right? It's not an exhaustive list. Did you see the tweet from John Guy replying to Obama about revisiting Brown v. Board of Education? Yeah, but that's kind of just nonsense. Lawrence says equal protection not good. Men can also terminate a pregnancy. Unilaterally. It really all depends. If we're talking about identifying as a man, or whether are we talking about men, whether they are men. So now let me go. I just have to refresh this page to get some more the new supers that are coming in. Show all. Okay, so we have some more that's come in. Oops. Let me go back to this screen. Here we go. Oop. So, hey, Nate, did you see Legal Mindsets? Did you see Did you see Mike going over a list from Herd's fans and what they say about you and everyone else? Love your work. Also, cruising still valid when the court decided to force MedPro on people as part of their job. Yeah, it is, because they're saying you have the right thing. And thank you for the generous super chat. Yes, and the reason why is that they're saying the government is not forcing you to take the vaccine. They're saying it's a condition of employment. So if you don't want to take it, you just lose your job, which essentially, but in the cruising case, it was, you've been found guilty of these crimes, we're going to sterilize you, right? You didn't have a choice. But in the vaccine cases, they were saying you did have a choice. But I think an argument can be made, though. I would make the same argument you're making, Cloudfire. I would make, and I don't think it's an argument you can laugh out of court. If a physician assists suicides, this is from Danny S. A private medical decision is not a right. By extension, an abortion, a private medical decision, is not a right. Interesting. You say everybody's, what is that? But again, this logic makes sense. But does it survive Palco? Does it survive the Palco test? That's what the court is saying. This does not meet the requirements for Palco. That's why this is no good. Thomas got the opinion in Bruin and could actually write his own reasoning because he didn't have 5 votes for it. But he wrote it in his Dobbs concurrence. Yeah, I think he did. I think the Dobbs concurrence is pretty good. But I don't know if the court's ready to go that far. I'm a little behind. I thought Thomas had a bigger problem with substantive due process. He has a huge problem with it. And the right to privacy, he thinks is just nonsense. Substantive due process, he thinks is just the wrong place. Right to privacy, he thinks is just nonsense. And applied over broadly. Not that the right of privacy is wrong unless it's attached. No, he the ones that are attached, he agrees with. The ones that just right to privacy as its own thing, he doesn't agree with. So that's where Thomas is at. All right, let me just refresh this page to make sure we're good and all caught up. All right, so that is where we left off at Big Worm. So let me just do one more. And all right, so that's it. We're good. All right, so listen, guys, let me see if I have any non-super chat questions that I can get up real quick. All right, so now we got some more coming in. Hold on. Boop, 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 boop. Update. All right, so this one. Can the Constitution amendment need to recognize unborn as protected under the 14th Amendment, or could SCOTUS make the determination making abortion illegal in all states? Yes. They can find that based on, actually, I think if you want to get sick with this, I think they have enough to pretty much do that already. Think about it. In the history, right? Let's use the Palco test to see if this even works. Think about it. Palco test says, can you attach it to any other? Essentially, can you attach it to something that's already there? First Amendment, no. Fourth Amendment, no. Right? You can't really attach it. But is it deeply rooted in our traditions and conscience and all that stuff? Well, before Roe V Wade was passed, it's pretty much illegal everywhere. From the beginning of the Republic, right? It was always protected. Protect this life, protect this life. And now if you say, well, traditionally, yeah, this was a protected, this life was protected all the way through. And it was deeply rooted in our nation's traditions. So I think they can go that route and say, yes, we're going to protect the unborn child under Palco and make it a constitutional right. I don't know if they'll go that far, but an argument can be made. And that's what I'm trying to explain to you people, right? You make the argument using the test that's there, right? And if you use the test that's there, I think you can get there. You can get there. And this is me training you how to be a lawyer, but you can get there. And I think if you have a astute enough attorney, he can get you there. Chet Murphy, I know it can be found unwritten, but if they really think everyone agrees it's so obvious. Just write the amendment and move on. You're a Scalia. You're like Scalia. That's what Scalia says. Damn all this. Just write. Just amend it. There's a process there. Just amend it. I'm with you, Chad. It makes it so much better, but that's just not the way it works. Tyler Wood says, thought on states' rights to nullify unconstitutional federal laws as a means of decentralized power. It's the supremacy clause. So if a federal law, if they believe the federal law is unconstitutional, they don't have. It's the Supreme Court that has to do that, unfortunately, because you got the supremacy clause. So even if the federal government passes a law that's unconstitutional, it's the Supreme Court that's got to declare it unconstitutional. The states gave that up when they agreed to give the federal government the supremacy clause. The states, remember, the way it works is the states give up part of their sovereignty to create the federal government, and a part of that sovereignty was the supremacy clause. They're saying we're going to be subservient to federal law. So that's why. To me, it seems like big government has a big player in how divided we are as a country without succession. Yeah, but again, the way it works is that each state has given up a piece of their sovereignty, and part of that sovereignty was the federal government is supreme. Thank you for the awesome content. I'm glad you could catch. Glad I can catch one. For one, thank you so much. Thank you so much. I'm assuming nobody's going to watch this because it's so deep. It's so deep enthralled and all that stuff. I'm assuming people are going to be like, me, I'm not going to watch this. What is it? 1 hour and a half hour stream about Roe v. Wade. Nate is just, just going crazy here. But those of you who did watch it, I do want to know. I'm in the comment section later, or even if you want to comment now. Did you learn something? Was this informative? Do you feel more informed now? No matter the way you feel about it, do you feel more informed on the process? Because that's what this was about, to inform you. So if you're going out there and argue with people and they start saying crazy stuff, like, okay, this, and now you have the receipts to back it up. Kavanaugh, in his concurrence, wrote that he wouldn't go for it. Oh yeah, he did. That's true. That's true. You see, I've been reading some of these Supreme Court to give you this, guys. It's been crazy, but you're right though. That's right. It's good catch. The biggest issue with all other unwritten rights and abortion is another life involved that is obviously negatively affected. The issue is, when does that life matter? Which is why it is so hotly debated. Yeah. And that's the issue that's always been out there. It's the issue that's always been out there. Question. You have the right not to get pregnant, correct? Well, hold on. You do. But let's say brain fried. I'm going to ask you a question. What about in cases of incest and blank, right? Would you accept, because a lot of states now are saying that even in that case, right? Compulsory pregnancy. So we're talking about somebody physically does something to you and compulsively impregnates you. Certain states says you still can't have the procedure. So are you there? Are you saying that? Because I'm totally against that, right? If somebody compulsively does something to someone, we're talking about something different. If someone makes a choice to have something done, now we're talking about two separate issues. So I don't think compulsory pregnancy is that's something that I think could be fleshed out a little bit more. And sex is your right to waive that protection. Correct. So we're talking about consensual sexual acts. We're not talking about non-consensual. How would the law gain the right to avoid that consequence? You have the right to not be poor. Yeah, but I think here the distinction is I understand what you're saying, but this is it's interesting because in one instance I think I agree with you, but then on the back end I can't agree, because I think if you're essentially saying the fetus is alive and has the right. I think you can make that argument, and I think you can make a damn good argument for it. But now it's whether the conservative justice of the Supreme Court will buy it, and I just don't know if they will. I just don't know if they will, because that's a bridge. That's going really far. That's going really far, and that's essentially saying no matter what happens, if that woman gets pregnant, then that baby has just as equal right as her. And what about for the life of the mother exceptions? Right? It's tough. It's tough because you could essentially do it, and now your life's in jeopardy. You know, it's too. I think it's way too complex to try to make it just a hard line rule, and that's the thing that we've been struggling right now for. It's just so much to do. I'm sorry. I'm I wish I had something witty to say or something, but it's just I think it's just too contextualized to just make some hard line rule like that. I think my biggest takeaway pro-choice people can get here is with the constitutional amendment. They can get post birth abortions up to 18 years past. I don't think so, because then you got all these other conflicts with these other constitutional amendments, right? So yeah, no, you're not. Then constitutional amendment isn't coming anytime soon. We're all working under the Ninth Amendment. This whole scheme is Ninth Amendment. We're not going to. The constitutional amendment is a pipe dream. So if anybody thinks there's going to be a constitutional amendment, I think you guys are just people are just missing it. People are just missing it. Chat Murphy, but thank you though. The constitutional amendment is happening. Abortion will be back, and I bet you it's going to come back under the Ninth Amendment under equal protection. I'll bet you $1. Just to complain. When states agreed to give up their sovereignty, they weren't aware that interstate commerce would be used to make everything virtually a federal law constitution. Yes, that's true. This is, I can't explain it, but he's right though. He's right. But they agreed to give it up. Like everything is under commerce. That's true. That's true. You made me laugh today. That's such a true statement. Any lawyer would understand why that's so true. Bad consequence of a cape can be a broken hand that lasts forever. It's a really tough moral question, but it depends on what you hold when life begins. Facts. Very, very good, very great super chat. Thank you so much for explaining this to us. Thank you for coming, and thank you for the generous super chats, guys, and thank you for being here, and thank you for the questions. I really hoped I answered all the questions. I know I couldn't answer everything, and again, I just before I leave, because I have to go and do some things, but I want to just make a couple of things. I want to just make very clear. First, this is a super simple explanation of something a lot more complex, and I've just dumbed it down to really make it digestible for somebody who's not a lawyer, somebody who's not going to read all these cases, and to really point you in places to go to understand the legal reasoning and the points and how the courts are deciding this. But again, this is a very, very simple, I've made it extremely simple for you to go find and look at. If you want to go do further reading, you can, because obviously just look at the sites and things that I've provided. But, this is a very simple, it's not going to answer all the questions, but it at least lets you understand where to look, how it works, and how to how to challenge it if you want to challenge it in the future. John O'Brien says, cough the 10th Amendment. Yes, John. Yes, you are 100% correct. The 10th Amendment. Could a future anti-Dobbs SCOTUS declare that the 50 years of post-Roe is adequate tradition for, or is that circular reasoning? Yes. Yes. What tradition? Whose tradition? They can say, yeah, Roe's tradition, it's settled, right? We have 50 years of case law, right? How far does tradition go? What's fairness, right? Fairness for the first 50 years. People obviously think this isn't fair. If you think you get 5 justices in a court who thinks, yeah, this is deeply rooted in our nation's traditions, our new traditions. Yeah. This can go on forever. But that's what happens when you got people determining what this means. So again, this doesn't depend on whether you think this is a good ruling or a bad ruling. Now at least you know why the ruling happened. And I think that's the most important piece of this. That's what this is all about, why it happened, and be able to argue and articulate the process. My daughters have now decided to have tubal ligation. Oh, tubal ligation. I get it, tubal ligation. I'd advise any woman to get that done at this point. Not worth the legal and medical risk. Interesting. Or contraception, but now that may not be a right. So interesting. Everybody has their reasons for what they're going to do, what they're not going to do. But now that's it for Super Chats. I want to say thank you. Listen, for everybody who gave Super Chats today and for all the questions I was trying to answer. I hope this happened. I hope I was able to explain it clearly enough. If you have any other questions, meet me in the comment section. Slavery existed for 100 years. For actually, beginning of time, right? Beginning of time. But what did they do? Right? They went over the Palco test, right? They even, you had a case before that said, yeah, slavery was good, right? What was it? Now I'm going to forget one of the most famous cases. How did I forget this? Dred Scott. Dred Scott's Supreme Court. And Dred Scott said, yeah, there's a deep tradition of this. It's here. This is before Palco, though. But it was, obviously, it's been beginning of time. So what did they do? Pass the constitutional amendment, the 13th Amendment, that said we don't give a damn about the tradition. There's a constitutional amendment. We're writing it down that is banned. And that's where we're at now. So that will be the process right now, right? To overrule the Supreme Court, pass the constitutional amendment. So you're right. It's wild how this thing works. But as you can see, there's logic to the madness. And now you guys are learning that logic to the madness. This is exactly what we needed. Thank you so much. Thank you so much. And thank you guys thank you guys so much for the super chats. Thank you guys so much for being here. I hope you learned something. If you really, really like this channel and you really like what I do, don't forget, like, share, subscribe, do like great YouTube stuff. Don't forget, you definitely like the video, because if you don't like the video, it's going to be, going to the ether. And if you can also meet me over at Locals, because I'm going to start doing some live streams over there, just to give you a more there's less people there, and we can actually get a lot more questions and have a better conversation than we can here on YouTube. So thank you again, brother. I really, really hope you guys, my brothers and sisters, I really, really hope you enjoyed this. I did a lot of research for this. I'm going to have a shorter video come out that's just going to put it in like a quick 15-minute format. So I hope you guys enjoy that. My name is Nate the Lawyer, and I really, really hope to see you next time.